It's just about 11 a.m. in Washington. The Supreme Court issued a major ruling on affirmative action in the 6-3 decision. The justices ruled that the consideration of race in college admissions is unconstitutional. We want to bring in CBS News legal contributor Jessica Levinson, CBS News senior White House and political correspondent Ed O'Keefe, and NAACP President Derrick Johnson. Derrick, let me go to you first. I know we just spoke about this in the last hour, but for viewers who are just joining us now at the top of the hour, your reaction to the Supreme Court decision ruling against affirmative action.
But the Supreme Court has failed America. It is unfortunate that we are not embracing diversity and opening up opportunities. For the centuries of harm directed, state-sponsored, against African Americans, a few decades of a program that was not perfect should not be eliminated. The worst thing about affirmative action is that it created Clarence Thomas. So this is a sad day for the future of this nation, and corporations, institutions of higher learning must do all that they can to ensure diversity in their spaces.
Jessica, I want to just go to you and get you to kind of break down the decision of the court and the dissent.
So a majority of the court here, as expected, struck down the University of North Carolina and Harvard's policies that explicitly use race as a factor in admissions, and said that both violate the 14th Amendment Equal Protection Clause. And Anne-Marie, I think this is something that you and I talked about after oral arguments, which is there's one view, and this is the majority view, that the Equal Protection Clause says no discrimination on the basis of race. And that means essentially don't take race into account because that is discrimination. Another view, and that's the view by the dissent, is no invidious discrimination, meaning that equality, the 14th Amendment Equal Protection Clause, it says that you cannot deny any person equal protection under the law, that equality can allow private actors and in the government, in the case of the University of North Carolina, to take race into account because things like racial diversity in a student body is a compelling government interest. It's something that is good for everybody. I think what's really interesting for people to note when they think about affirmative action is that, legally speaking, the justification has not been to help people who have been subject to systemic racism and systemic problems. Legally, the justification is it's good for all of us to have students who are in a racially diverse class. And that's what we really lose today, in my view.
Yeah, I think that's a really good thing to point out, that it was never about sort of righting the wrongs of the past or anything along those lines. It's because a diverse student body is a great environment to learn in. Can you sort of flesh out the dissent for us?
Right. So what the dissent was saying is that the Equal Protection Clause does not bar consideration of race. The Equal Protection Clause bars, again, invidious discrimination. So we make distinctions all the time. The government draws lines all the time. And what the dissent is saying here is, and I think Justice Jackson has this line, this let them eat cake approach, this blindness to what our society really looks like, is a problem. So I'm going to point out two things about the dissent. One is they legally take on the majority and say, that's not my reading of the 14th Amendment. The 14th Amendment allows us to take race into consideration to get to that compelling governmental interest of racial diversity. But the other thing that the dissents do, and we heard this in the oral arguments, is that they talk about the practicalities of this. What happens outside the courtroom? We know what happens is that the number of Black and Latino and Latina students drops. I'm talking to you from California. We've banned affirmative action for years. We know what happens. And in that case, we know that colleges and universities are a pipeline to society. So we're not just talking about colleges and universities, we're also talking about a ripple effect. And that's something the dissents bring up, and they talked about in oral arguments as well.
So beyond that ripple effect, though, does this decision have implications outside of school admissions?
So as I read as quickly as possible, not explicitly, but certainly we're going to look at this rationale, and I'm sure that it will be taken into other arenas.
Okay. Thank you so much, Jessica. We're going to pivot back to Derrick. And actually, Derrick, I'm going to ask you about the other case that I never got a chance to ask you about that we haven't gotten a decision on. President Biden's loan forgiveness program. The court is going to be looking at a couple of things, whether or not those who have come forward, a couple of individuals in a few states, even have legal standing, but then whether or not this can be done, whether or not the president can forgive loans, or whether that should be in the domain of Congress. But I want to ask you about what will happen if this student loan forgiveness program doesn't go forward, because we know that Black and Hispanic students share a tremendous burden when it comes to loans, student loans.
So let's set the table here. The reason why you had so many individuals borrowing money to go to colleges and university is because states across the country, in lieu of cutting taxes for the most wealthiest individuals and corporations in those states, they increased tuition. Mm-hmm. And as a result of increasing tuition, Congress did not increase Pell Grant. So the cost of going to school went up over the last 20, 30 years. During the exact same time, you have more Blacks and Latinos attending schools, particularly Black and Latino women. And so we enter into this space of having a predatory financial reality for individuals who were simply trying to advance in life through education. We should not be funding education on the backs of working poor individuals. And so what the Biden administration did was to try to give some relief for those individuals as a result of student loan debt is a super debt. You cannot discharge it in bankruptcy. Unlike the former president who filed multiple bankruptcies, the student loan debt, had he had any, would have remained a part of his liability. That's unfortunate, that's unfair, and we must give people a ladder up. If the Supreme Court rejects this administration's ability to forgive upwards of $20,000, this administration must do all they can to alleviate that financial pressure from individuals who simply were trying to progress in life through education.
Derrick Johnson, President and CEO of NAACP, thank you so much.